laws, if anything, should employers be concerned about when they're about to institute a mass layoff or a mass reduction in force?
That's a great question, Sammy, and one that we have unfortunately been hearing all too often in these recent times. So the biggest law, and the law that we're really going to be focusing on today, is the Federal WARN Act, which covers all private U.S. employers that have 100 or more employees. So if you have 100 employees or more than 100, you are covered by this law. And what this law requires is that if you're going to do a RIF, or a reduction in force, of a certain amount of employees, you have to give at least 60 days notice in advance of that RIF. So the way that the notice is required, whether or not your layoff is big enough, is if over a 6-month period you're going to be laying off 50 or more employees at a single office, work site, or location, or 33% of your entire active workforce. So this would also include furloughs or temporary layoffs that last 6 months or longer. So that's the federal requirements. Now, I do want to just pause really quick and note that there are some states that have their own versions of WARN. They're called mini WARN Acts. Mm-hmm. And those can vary. Some of them do require 90-day notice. Some of them don't. But just to keep things nice and simple, we're going to focus on the Federal WARN Act today. Specifically, what happens when you can't give 60-day notice.
Mm-hmm. Understood. So the two big categories for employers to be aware of, as long as they have 100 or more employees, is 50 or more employees in a single office being terminated or a reduction in force impacting them, or 33% of the workforce across the entire board.
Yep.
Got it.
Yep. And again, that's in the aggregate. So if you lay off, you have, let's say, an office in Tyson's here, you lay off 25 employees in July, and then in August you lay off another 25 employees, that would be 50 because it's within that 6-month period.
Got it.